Here we are, testing. Okay, welcome everybody. Today we're talking about what happens if the doctor refuses to answer my questions. That's what today's topic is. So let's take a look at my fancy ticker tape going by. What happens if the doctor refuses to answer my questions? You ready with my fancy graphic? Here we go. Please stand by while we watch my fancy graphic move on. What if the doctor refuses to answer my questions? That's going to be today's topic involving pretrial question and answers. Okay, what if the doctor refuses to answer my questions during pretrial testimony? That's what we're talking about today. So it's going to be fun, it's going to be interesting, I hope it's going to be entertaining. And just give us a few moments and we're going to stand by and then get started in just a few moments. I know I can't compete with the former FBI Director Comey's testimony. I'm pretty sure that's over at this point, but there's still a lot of news coverage going on with it, so let's see if I can break into it. And here we go. What if the doctor refuses to testify and answer my questions during the course of his pretrial testimony? Notice my fancy three-dimensional graphics. Nobody does this. Nobody. Well, maybe one or two, but guess what? They don't do it as well as I do. You want to know why? It's because it's so simple. It's easy. Oh, some people won't use it because it doesn't look professional. You know what I say to that? Who cares? As long as you know what the topic is, that's important. So, what if the doctor refuses to answer my questions? All right, so we are now ready to get started. Hi, everybody. I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. And in today's video, you know what we're talking about. What if the doctor refuses to answer my questions during the course of his pretrial deposition? That's what we are talking about today. All right, so here's the scenario. The scenario is you've brought a lawsuit against your doctor claiming that he was careless. And as a result of his carelessness, you now suffered significant injury. Excuse me. All right. Your doctor, on the other hand, and by the way, we have a medical expert to confirm that number one, your doctor was careless. Number two, that his carelessness was a cause of your injury. And number three, that your injury is significant and permanent. So what happens next? So now we get the lawsuit started. And now the doctor has to answer the allegations. And there's a document there that the doctor's attorney has to prepare called an answer. And the answer basically says, hey, why are you suing me? I did nothing wrong. And if I did something wrong, so did you, Mr. Patient. And if I did something wrong, well, guess what? Whatever I did or did not cause or contribute to your injuries. That's really important. So that's exactly what he's going to say. And then he's going to argue, you know what? If I did something wrong, and you, the patient, did something wrong, and maybe whatever I did caused or contributed to your injuries, you know what? Your injuries are really not as bad as you claim them to be. That's the four typical defenses we see in these medical malpractice cases. So what happens then? Well, now we go through the litigation process because basically what's happened here is that there are two competing opposing set of facts, two competing opposing sets of claims. You, the injured patient, say the doctor was careless. The doctor says, no, I wasn't. You say it's day. The doctor says, no, it's night. You say it's 5 o'clock. The doctor says, no, it's 10 o'clock. So they are arguing about every single issue that you raise. So what happens at that point? Well, now you go through that litigation process. And what that means is that a few months after you start your lawsuit, you will be asked to appear in your attorney's office where the attorney for the doctor whom you have sued will have an opportunity to question you. And he'll do it in your lawyer's conference room. Now, there's no judge present. There's no jury present during this questioning. But instead, there is a court reporter there to record all of your questions and to record all of your answers. I shouldn't say your questions. All of the attorney's questions and all of your answers that you give, right? So we haven't yet gotten up to what happens if the doctor refuses to answer my questions. Right now, I'm simply showing you the process. Legally, it's known as a deposition. This is pretrial testimony. And you should know that everything that you say is being recorded by the court reporter. And even though you're in your attorney's office and it's a bit informal, the mere fact that you are giving answers is sworn testimony. And by the way, that testimony carries the same exact weight as if you are testifying at trial, as if you are testifying in front of the judge and in front of the jury. So if you're joining me for the first time, I want you to give me a shout out, say hello, tell me that you're here. If you have questions, I want you to post them in the comment box, and I'll be happy to address it, because today we're talking about what if the doctor refuses to answer my questions during pretrial testimony. All right. So now, during your pretrial testimony, you can expect to be there for hours, if not days. Sometimes attorneys question you for days, but for the most part, it's hours, or it might be a full day. And they will go ahead and ask you lots of different questions. After you are done with that question and answer session, now, a few months after that, we will have an opportunity to question the doctor whom you have sued during the course of his pretrial deposition. And this will be done at his lawyer's office, in his lawyer's conference room. And again, there's no judge present, there's no jury present. So who is there? Well, you have the doctor whom you have sued, you have his lawyer, you have a court reporter, again, who's going to record all of my questions and all of the doctor's answers. That's it. Typically, we tell you not to come because you're going just to get very upset and very angry listening to the doctor's answers. And we tell you about it, what went on, and all the details later on. So, what happens next? During the course of my questioning, I will have a series of questions that I need to ask the doctor. And you should know that every lawyer, every good, experienced lawyer in New York who handles these types of cases has an agenda. Now, why would an attorney have an agenda going in to question a doctor? It's because if it's done right, we have the opportunity, we have the ability to prove our case, to prove that we are entitled to a verdict during the doctor's pretrial questioning before we ever get to trial. That's the goal here, to not only to establish what the facts are, but to lock the doctor into his testimony and to prove our case. Now, how do we prove our case? We have to show that we are more likely right than wrong, that what we are claiming is true. Now, you might be thinking, how do you get a doctor to do that? How do I get a doctor to admit that he did something wrong? How do I get him to turn around and say, yes, that my carelessness was a cause of your client's injuries? Well, I'll tell you something else, and you may not be aware of this. The best attorneys in New York are able to do this. And they do that because they have an agenda, because they are fully prepared, because they know the medicine, because they know and understand what elements, what factual elements need to be shown, and get the doctor to admit them during the course of this pretrial question and answer session. So this is really, really important. So let's take a quick water break, and I'll continue in just a moment. All right. So remember, today we are talking about what if the doctor, during his pretrial question and answer session, refuses to answer my questions. So now I'm asking the doctor questions. And you should know I have the ability during this pretrial question and answer session to ask him short leading questions. Doctor, isn't it true that on January 1st you saw my client? Yes. And on that day my client complained to you of the following things. True? Yes. And you recorded that information. Isn't that true? Yes. And at that point it's important for you as a treating physician to go ahead and obtain a detailed, thorough medical history. Isn't that true? Yes. And why do you do that, doctor? So now I'm asking the doctor a question to explain. Now, very few times will I ask the doctor to explain anything except during pretrial questioning. And there's a key reason why I want to do that. And for those of you joining us, what if the doctor refuses to answer my questions during pretrial testimony is today's topic. So stop by, say hello, let me know you're here, ask me any questions about what we're talking about, and I'll be happy to address them. So let's get back to the questions that I'm asking the doctor. So now I'm asking the doctor, hang on, excuse me, what am I asking him? I'm asking him certain questions that I want him to agree with. And I'm asking him to explain certain things. Doctor, why is it important for you to take a detailed, thorough history? You want to know why? I need to know it. And so ultimately later on, a year or so from now, when the case goes to trial, I want to be able to read that testimony to the jury to explain in the doctor's own words why it's so critically important to take a detailed, thorough history. Okay, so now I'm going to be asking the doctor a whole series of questions called hypothetical questions. Now, a hypothetical question asks the doctor to assume that certain facts are true. So remember when I told you earlier that the doctor disputes practically everything we're claiming in this case? We say he was careless. He said, no, I wasn't. We say he did this. He said, no, I didn't. We say he had this conversation. He says, no, I didn't. There are many factual disputes. So now, if I were to go ahead and say, doctor, didn't you do this? He'd say, no, I didn't. And that would be the end of it. I can't ask beyond it because he's denied that making that comment or denied doing that treatment. Well, that's not good enough. I want to turn this around a little bit. I want to ask the doctor, hey, listen, I want you to assume for a moment that my client, no, let's try it this way. I'm going to ask the doctor, oh, notice the squirrel going back and forth on the wires? So what I want to do is I want to ask the doctor a series of questions that assume certain facts to be true. Now, you might be saying, why would the doctor ever answer questions like that? Well, in New York, the law allows me the opportunity to ask a doctor to assume that certain facts are true. And I'll tell you why that's so critically important in just a moment. So now, here's what happens. I'm going to say, doctor, I want you to assume that these facts are true. And based upon that, I'm going to be asking you a series of questions. Now, I want you to assume that my client, Mrs. Jones, came to your office on January 1st, and now she had a complaint of a breast lump in her right breast. Assuming that fact to be true, would you agree it's important to talk to the patient to find out how long that lump has been there and to ask her a detailed, thorough history about her complaint? And he has to say yes, right? Otherwise, he's going to look really, really foolish. So that's number one. Then I'll continue on the series of hypothetical questions, facts that we believe to be true, that we can support with my client's testimony, with the medical records, and with expert witnesses. So, doctor, I further want you to assume that she complained of having this breast lump for a total of 1 month before coming into your office. And I also want you to assume, and now I'm going to take him down a path, telling him certain facts to be true. Based upon those facts, assuming those facts to be true, doctor, would you agree that good medical practice requires a physician at that point, after taking a detailed medical history, to perform a physical examination? Yes, I would. Why is that important, doctor? And now I'm going to have him tell me in his own words why it's important to do a detailed physical examination of the breast specifically. Okay? And doctor, isn't it true that when you do a physical examination of the patient's breast, you do it sitting up as well as lying down? Yes, you do. Tell me why you do it both sitting up and lying down. Now, again, he's going to tell me what the standard of care, what good medical practice is about why it's so important to do a physical exam in that instance. So let's say in this factual scenario, it is our claim that the patient complained of this breast lump, but the doctor did not do a physical exam, nor did he refer her out to a breast surgeon to have certain tests or biopsy done. And now, what's the doctor doing? He's got to admit certain facts to be true. And even if he doesn't, if he says, no, that's not true, and listen, I'm not gonna answer these questions because I disagree with your questions, Oginski. If he turns around and says, I'm not going to answer your questions because your facts are incorrect, what do I do? Well, what I do is say, doctor, listen, the law allows me the opportunity to ask you certain questions, to ask you for the moment, to put aside your version of the events, and to turn around and acknowledge that these are our version of the events. And if, in fact, our version of the incident or the facts are true, assume that to be the case, would you agree that failing to do a thorough, detailed history, take a thorough history, would be a violation from the basic standards of medical care? I'm not going to answer that question, Oginski. That's improper. I disagree with those facts. Now, the doctor may throw a tantrum. He may disagree. He may start yelling and screaming at me. How are you? Nice to see you. Come join us. I'm talking about what happens if the doctor refuses to answer my questions during pretrial questioning. So the doctor may get very upset and say, I'm not answering your question, Oginski. That's ridiculous. This is nonsense. That's not what happened. It doesn't matter what the doctor thinks. I am entitled to get an answer to my question. In fact, the doctor is required to give me an answer. And his attorney, in all likelihood, is going to turn to the doctor and say, doctor, listen, there's nothing wrong with Oginski's question. You have to answer it. Now, the doctor has a key reason for why he doesn't want to answer my question. He knows what's coming. He knows what I'm going to do with that answer. Those answers are going to come back to bite him in the butt. And I'll tell you why in a moment. The doctor is doing everything possible not to admit that if a doctor did not take a thorough history, It's a violation from the standard of care. The doctor is going to do everything possible not to have to answer my question, which says, listen, if you didn't do a physical examination in light of the patient's complaint of a breast lump, that you would agree, doctor, that that would be a violation from the basic standard of medical care, correct? Assuming those facts to be true, right? So today's topic, we're talking about what if the doctor refuses to answer my question during pretrial testimony. So I can try and coerce the doctor or convince him that his failure to answer is going to have severe repercussions for him. More importantly, his lawyer is going to turn to him or take him out and say, listen, doctor, you've got to answer these questions even though you don't agree with the questions, even though you disagree with the facts. So he can fight me all he wants. But what happens, though, if after all of that, after I tell him he's got to answer the question, after his lawyer tells him he's got to answer the question, what if he still refuses to answer the question? So now I have a couple of options. My first option is to call the court, to call the judge who's supervising this case, and say, Judge, listen, I'm here at a pretrial deposition with the doctor who's being sued and his attorney, and the doctor is refusing to answer my hypothetical questions. Now, the judge has a number of options. The judge can get on the phone with the defense lawyer and tell him, listen, he's got to answer these questions, otherwise he's going to suffer severe repercussions. Otherwise, I'm going to bring him back at another day, take up more of his time, and now, in addition to that, he could be fined, he could be sanctioned, and there's another extreme I'm going to tell you about right now. So let's say, for example, that the judge does not take telephone requests while we're at this question and answer session. What can I do next? So the doctor's making my life, trying to make it miserable. He's trying to obstruct the whole process. He's trying his best not to answer these hypothetical questions because he knows it's going to destroy him later on. So what do I do next? Well, at this point, here's what I do. I will move on. I'm going to make all of my objections known, make all of my concerns known on the record so the reporter has them down on the transcript, and I'm going to move on. And I'm going to continue forward asking the doctor other questions. And at some point, we're going to have to end because I will not have gotten the answers I needed. At that point, I will then go to the court, and in writing, I will ask the judge to take action. I'll show him the transcript, the questions that I asked and the answers the doctor gave, and the conversations that we had, and the obstructions, so the judge can actually see every single thing that went on. And now the judge can determine that this doctor was, in fact, obstructing my attempt to get all this detailed information. And in that instance, I'm going to ask the judge to do a few things. Judge, I want you to fine this doctor. I want you to sanction him. And I want you to strike his answer. Now, what does that mean? Well, I want the judge to give this guy not a penalty. I want him to pay for obstructing this process. This is a civil lawsuit process. The doctor has to answer my questions. In fact, there are only 2 instances where the doctor is legally okay and under the legally has the authority not to answer my questions. The first one is if I ask the doctor a question that's so off the wall, that is so outrageous, we call it palpably improper. So, for example, if I were to ask the doctor how many times he beats his wife each night, his lawyer would turn around and say, Oginski, that's palpably improper. That's objectionable. I'm not allowing the doctor to answer the question. And he'd be absolutely right. Okay, that's improper. Number 2 is if I ask the doctor about the details of his conversations with his attorney. His lawyer would be fully within his right to turn around and say, Oginski, that's inappropriate. That's privileged material. That is confidential. Attorney-client privilege. So I can learn that they had a conversation, but I can't find out the details. So those are the only 2 instances where if the doctor refuses to answer my questions, I would not be able to get that information. But in all other instances, I'm entitled to ask my questions, and I'm entitled to, and the doctor's required to, give me answers to my questions. So now, I'm going to ask the judge to strike the doctor's answer for failing to answer my questions. What does that mean? Okay, remember at the beginning of this video, when I told you how lawsuit got started? We prepare papers known as a summons and a complaint detailing all the allegations against the doctor. The doctor and his attorney have to go ahead and answer those allegations. And the paper that they prepare is called an answer. That answer basically lists all of the defense, denies everything that we claim, and it lists those defenses that I told you about earlier, where they say, hey, I did nothing wrong. I did nothing wrong. And if I did something wrong, so did you, the patient. And if I did something wrong, it didn't cause or contribute to your injuries. And, and by the way, your injuries are not that bad. So that's what happens. That's what an answer is. Now, if I ask the court to strike the defendant's answer, you know what that means? It means that we get an automatic win if the judge agrees with us and agrees to strike their answer. It's as if they never answered the lawsuit to begin with. It's as if, let me give you a great example. Let's say we are going to a Yankees game, and now we're going to watch the Yankees play the Mets. And we're waiting, and there's a delay, and it turns out the Mets just don't show up. For whatever reason, they don't show up. So now they finally call the game. It's an automatic win for the Yankees. Well, that's great. Terrible for the fans because we missed out on a great game. But guess what? We get an automatic win. The Yankees, by default, get the win. Well, what does that mean? Well, it means they won by a technicality because the Mets didn't show up by default. But it doesn't mean they won the game on the merits. The same exact thing applies in a lawsuit. If a judge turns around and throws out the doctor's answer to the allegations, it's as if we get the win on default, on a technicality. We don't get it on the merits. But what happens then is that now we will have a trial months down the road. And the trial will only be on how much the jury is to give you for all of the harms and the losses and damages that you incurred. We no longer will have to evaluate whether or not your doctor was careless, and nor will the jury have to evaluate whether his carelessness was a cause of your injury. So how do you like that? If the doctor refuses to answer my questions during the course of pretrial testimony, the judge can fine him, the judge can sanction him, the judge can order that he return back to the attorney's office to be present for my questioning and compel him to answer my hypothetical questions. Doctor, I want you to assume that if a doctor did not do the following A, B, and C treatments for this particular condition, that would be a violation for the basic standards of medical care. True or false? So now he has to answer the question. He's obviously going to say false, and that's okay. I want an answer. But if he refuses to answer my questions, now he's creating a problem for himself. And it simply means I'm still going to go ahead and do everything possible that I need to in order to get answers from the doctor, because he has to answer these questions. So why is it so important for me to get the doctor to answer these hypothetical questions? I'll tell you why. You've waited this long, and now I'm going to share with you the critical answer for why the doctor does not want to answer these hypothetical questions. The doctor knows that 6 months from now, a year and a half from now, when the case ultimately gets to trial, I'm going to be asking the doctor a series of hypothetical questions, the same ones, at the time of trial. And now, remember, we have our own set of facts. The doctor has his version of his own sets of facts. And here's the key. If the jury ultimately, after hearing all the testimony and all the evidence, if they believe our set of facts are more likely true than not true, then guess what? Now, the doctor's own words, his own testimony will have proven our case. Because then he will show, then we will have been able to show through the doctor's own words, what? That guess what? We'll be able to show that the doctor was careless based upon the hypothetical questions that I asked. That's really, really important. So using the doctor's own words, using his own testimony, if we are able to show, and the jury believes that we are more likely right than wrong, well then guess what? Now we are much more likely to win the case in our favor compared to not having the doctor answer those questions, those hypothetical questions. That's why you will find that the best lawyers in New York, the most experienced ones, have an agenda when questioning a doctor during pretrial testimony. The whole goal is to try and get the doctor to explain what the standards of care are for treating this type of condition. And what else do we want to do? If we want the doctor to assume that our sets of facts are true, and if certain things were or were not done, They are either a departure from good and accepted care or they are not. And if I can get the doctor to admit those things, I am already on the way to proving our case, and maybe it'll help resolve this case before we ever get to trial. So why do I share this great information with you? I share it with you just to give you an inside look at what goes on in these medical malpractice cases here in New York. You know, I understand you're watching this video because it came up in your Facebook feed, or if you're watching this on the YouTube replay, then you're clearly searching for this information. Well, if this information helps you understand and you have more questions, and your matter did happen here in New York, and now you need more questions, well, what I invite you to do if you have not yet started a lawsuit is pick up the phone and call me. Okay, now you're going to follow the bouncing finger, and I'm going to give you my phone number, which you see right down here. Ready? 516, here we go, 516-487-8207, or by email at Gerry, here we go, Gerry, Gerry, at Oginski-law.com. Well, that's it for today's video. I'm Gerry Oginski. I hope you guys have a wonderful day. Bye-bye, everybody.